Hello, my name is Mark Jones and I'm a partner in the Employment Department at IBB Law. To say that we are living in unusual and unprecedented times is an understatement, to say the least. Some of us are fortunate to have continued to work during the lockdown, and we at IBB Law, like many other organisations, have been using video platforms to communicate with colleagues and clients. However, the lockdown has resulted in many businesses closing on a temporary or permanent basis. We've seen the government create the Coronavirus Job Retention Scheme and introduce the concept of furloughing employees. On the 12th of July, the total number of jobs furloughed was 9.4 million, comprising of 1.2 million employees at a cost of £28.7 billion. The scheme will end on the 31st of October. With the easing of lockdown and businesses reopening, it has created new challenges for employers and employees alike, not least how to make those businesses safe in accordance with government rules. Unfortunately, as many businesses navigate their way out of lockdown, this may have resulted in reduced sales and services and led to the need to make redundancies. A redundancy situation may arise where the requirements of a business to perform work of a particular kind has ceased or diminished and could result in dismissals. In such a case, employers will need to comply with employment law to ensure that any resultant dismissals are fair. For example, a chain of fast food restaurants such as Burger King is not processing the same number of orders as it did before the pandemic. Therefore, the requirement for the number of employees to provide a particular type of work in those restaurants may have diminished, giving rise to a redundancy situation. Where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, the employer must collectively consult about the dismissals of those employees placed at risk of redundancy at least 30 days before the first dismissal takes place. As part of the collective consultation process, employees can elect employee representatives if none exist and there is no recognised trade union. The process is set out in legislation. An establishment means the unit to which the employees have been assigned. It is not essential that each unit should have its own management, which could have carried out the redundancy process itself. Therefore, in the example provided, the establishment would not be Burger King as a whole, but each individual restaurant. Consequently, collective consultation may not apply, and an employer will have to consult on an individual basis, which is not governed by a statutory process. However, as part of individual consultation, employers must discuss planned changes with each employee who has been placed at risk of redundancy and get their ideas and feedback for avoiding redundancies. An employer's plans must not be finalised at this stage. If an employer is seeking to reduce the number of employees doing the same type of work, they will need to be placed in a selection pool, selection criteria devised, and a selection process carried out. If an employer fails to follow a proper consultation process, any resultant dismissal could be unfair and lead to a claim for unfair dismissal. An employee that has been employed for a minimum of 2 years and dismissed by reason of redundancy is entitled to a statutory redundancy payment, which is calculated based on age, length of service, and capped at a maximum weekly amount, currently £538. Some employees may decide to make enhanced redundancy payments above the statutory redundancy payment amount. Employees may be required in those circumstances to sign what is called a settlement agreement. It is a legal requirement that employees must take legal advice on the terms and effect of signing a settlement agreement, and in most cases this is from a solicitor. An employer will make a contribution towards the legal costs in providing that legal advice to their employees. Over the years, I have acted for hundreds of employees, advising them on redundancy and/or the settlement agreement they have received. If you or someone you know is going through a redundancy process or has been offered a settlement agreement, I am here to help. I'm Mark Jones, and thank you for listening.